Muscular is greatly conveys.
Good evening, everyone. I, Ayushi Jain, Event Manager at Vidhi Sanskaar, warmly welcome you all to today's insightful session on Directive Principle versus Fundamental Rights, a powerful constitutional conversation that lies at the heart of Indian legal discourse. We are honored to with us Dr. Asis Mallick, sir, Assistant Professor, as Speaker 1, and Dr. Akash Chatterjee as Speaker number 2 for today's session. Over to you, sir. Thank you.
Hello everyone. Am I audible? Hello?
Yes, sir, you are audible.
Yes,
Okay,
sir.
okay. Okay. So my dear students, just today's topic is directive principles of state policy and fundamental rights. So I am asking you a very, very simple question first of all. And it is not a lecture session. I want an interactive session. Always I prefer it. Very simple question. What is constitution? If I ask you, what is constitution? Just I am a layman. I don't know law. I don't know constitution. If I ask you, please answer. Anyone?
Sir, Constitution is the supreme law of the land.
Just what is your what is your name, please?
Sir, my name is Sam Sion.
Okay, very good. So, what is constitution?
The supreme law of the land.
Supreme law of the land. Okay, very good. Anyone? Okay, Shan, very good. Anyone? What is constitution?
It is
Sir,
a
in
federal.
layman,
Yeah. Hello.
The act which regulates all the acts, the Mother Act.
Act, Mother Act. Okay. Then, if I ask you the next simple question, is it constitutional law? What is the difference between law and constitution? What is the difference between law and constitution? Suppose Hindu
So,
Marriage Act. Yes.
constitution,
What is your name?
Sir Nishi.
Okay. Okay, Nishi, please.
So, constitution is basically a book of law.
What is the difference between law and constitution?
Sir, Amar Singh here.
It is a
Yes.
book of law. Constitution, we can say that it is a book of law.
I
So may
can't
I?
hear. Yes.
So Constitution is a book
Nishi, I
which
can't hear.
is
Yes, yes.
in which
Anyone?
fundamental.
Anyone? What is the difference between
sir,
law and
constitution
Am
is
I
constitution?
audible?
Please.
The Constitution is the supreme law of the country, while the laws or rules created within the framework of that Constitution.
Said law is a series of rules and regulations, but the constitution is a
Yes.
series of rules and regulation of law.
As I think,
I can't
Constitution
hear. Please
is,
be louder. Please.
as I think, Constitution is a book in which fundamental principles are written, and Constitution law helps them to use and to oblige a person to enforce them.
Ishita, yes?
Good evening, sir. Law, accordingly, if we say law does not have a specific definition
What's
as
the difference
such,
between law and constitution?
sir, constitution is a set of principle due to which laws are made. And law does not have a specific definition as such. It is what we are obliged to follow.
No, sir, according to me,
Yes.
the definition, and the definition is a series of rules and regulations is called law.
Rules and regulation of?
A series of rules and regulations is called law.
Okay, and then what is constitution? Then what is constitution?
The constitution is the supreme law of the country, sir. It's the supreme law of the country. While laws are rules created within the framework of that constitution.
So,
The Constitution is the basic documentary form of law, whereas constitutional law is given by the judgment of the court based on the Constitution.
Okay, then if I ask you, just you take one act, Hindu
hello,
Marriage Act,
con-
Indian Contract Act, Indian Penal Code,
yeah.
then
That
what
is
is the difference between Constitution and Indian Penal Code, Constitution and Hindu Marriage Act, Constitution and Hindu Succession Act,
But what are
Indian Contract
the
Act?
rules that I want to answer? Law are rules that set. Yeah.
Yes?
Hello, hello,
Yes?
sir. Constitution is the fundamental legal documents of a country, outlining the structure of the government and fundamental rights.
The answer is Constitution is a set of principles. A set of principles on the basis of which, just listen carefully, on the basis of which legislators, they make laws. Just you say, I'm a layman, I don't know law, I don't know constitution. Then if I ask you, what is constitution and what is law? What is the difference between constitution and law? Then your answer will be constitution is a set of principles. For example, sir, what is the example of principles? Equality before law. It's a principle. Equal rights to everyone. Clear? And what is the reflection of the principle? In law. For example, Hindu Succession Act. Okay. So in brief, Constitution is a set of principles on the basis of which laws are created, laws are made. Legislators, they make laws on the basis of the principles of Constitution, on the basis of the philosophy of Constitution. But if the legislations, if the provisions of law don't comply with the provisions of Constitution, the
Sir,
principles
you
of
are not
Constitution.
visible to us.
Yes? Yes?
Sir, you are not visible to us.
Sir, your video is not visible, sir.
Okay, just a minute. Am I audible now? Hello?
Yeah,
Yes,
sir,
sir.
you are audible, but your video is off. They mean to say that.
Okay, okay. Then, so what is the difference between law and Constitution? What is the difference between law and constitution? Constitution is nothing but the set of principles on the basis of which laws are made. Clear? Clear to all of you?
Yes, sir.
Okay, then come to the next point. Fundamental rights and directive principles of the state policy. Just I have only 45 minutes and I have to explain fundamental rights and directive principles of the state policy. Okay, if I ask you another very simple question, very simple question, because law is very simple if you can understand. What do you mean by the term right? What do you mean by the term right? R-I-G-H-T-S, rights. What do you mean? Anyone?
It's freedom. It's
Yes.
freedom. That's an individual. Yeah, that's an individual process or an entity process. Like he had a freedom to do. Right?
Very right is a legal claim. Right is a very yes, Vidhi, yes. Right is a
Legal claim.
legal claim. Okay, I have a right, then I have a legal claim. Okay, so right is equal to legal claim.
So right is a legal claim that are enforceable by law and sanctioned by the state. That if I have a right, then it should be sanctioned by the state,
I just did, but I am
and it
asking
should
you.
be a
Yes,
it should be a legal right.
it
It
should
should
be
be
a.
a enforceable and recognized by the law and protected by the law. For example, if
Protected.
you talk about constitutional rights, so our state, that is our India, it recognizes the rights that are constitutional rights, as well as it is protected by the Supreme Court and the judiciary.
Okay,
So
Asta,
if our
suppose
right,
I. Okay, Asta, suppose I am walking on the road, okay? And you have come. I am
yeah,
walking on the road and you have come. You
hmm,
you have taken attempt to kill me. Have you any
hmm,
right to kill me?
sorry, I have a duty not to harm you, but you have a right to be alive, right to
You have
life.
a duty. Yes, you have a duty.
I have a duty to not infringe your rights.
And
It
who
will
says?
sort of, sir, I just now I will study jurisprudence. So as per that,
Suppose,
of
okay,
course,
okay. Suppose
every
I am walking. Okay. Suppose I am walking on the road,
yeah,
and I desire to kill Mr. X. I desire to attack Mr. X. Will it be protected by the state? By the
sir,
supreme?
but
No.
excuse me,
Yes.
sir, I would like to reply. But this
Yes.
right is not been recognized by the law, no? The state haven't been
Okay.
recognized that you
Just
have a right to kill someone. It is a
okay.
punishable offense and it is sanctioned by the law. Sanction,
Okay.
the term sanction means punishment. That is
Okay.
already given in
Okay.
BNS.
Okay. Then clear your concept first of all. So, what is the concept? What is the theory of jurisprudence? What is the interest theory of jurisprudence? Man lives in the society for his own interest.
Yes, sir.
My voice is clear. Someone has written my voice is not clear. Man lives in the society for his own interest. You have come in the online platform for your own interest. Yes, I have come here for teaching you. I am walking on the road for my own interest. I am eating food for my own interest. I am sleeping for my own interest. So all the interests are not protected by the state. Man lives in the society for his own interest. But all the interest of Asis Mallick, all the interest of Akash Chatterjee, all the interest of Asta are not protected by our government, our law. Why? because some specific interests are protected by our legislators, our laws, and these are called as rights. So rights is equal to protected interest.
We can say that
Protect, clear? Protected by whom? By the
by the
state,
state.
by the laws, by the sovereign. Concept is clear?
Yes, sir.
Clear? Okay. Now, in the year 1948, just I'm going to very brief. Have you heard the name of Universal Declaration of Human Rights? UDHR?
Yes, sir.
Okay. So our constitution makers, they inserted some basic rights following the UDHR after the World War II. Inserted some basic rights. Sir, what is basic rights? Without which there is no difference between a street dog and you. Basic rights. They inserted, they provided, named as fundamental rights for Indian citizens. Simultaneously, in another chapter, chapter 4, part 4, they provided directive principles for state policy. Now, my next very simple question is, what is the difference between fundamental rights and directives, directive principles for the state policy? Anyone? Yes, Asta Kumari has raised her hand. Yes, Asta? Tiyasha, yes, Tiyasha, yes.
Sir, fundamental rights are okay.
Sir,
Please speak.
fundamental rights is protected by the court and it is enforceable by the law. But directive principle is not enforceable by law, means it is not enforceable by court. If any conflict is arise between fundamental right and directive principle, directive principle always overrule. Sorry, fundamental right always overrule directive principles. Fundamental right.
Fundamental rights always overrule directive principles. Okay, I am asking a very simple question. Suppose I am a layman, I don't know law. Suppose if you, then please explain me.
Hello,
Yes,
sir.
yes,
Hello,
but
sir.
yes.
Yeah, fundamental rights are rights that are guaranteed by the Constitution according to Article 12 to 35 of the Constitution of India, while directive principles are not guaranteed by the Constitution. They are policies that regulate the government functions. Though they are in the Constitution, the directive principles are in the Constitution, but they are not enforceable. But fundamental rights are enforceable by the Constitution. That's the difference.
Okay, then anyone else?
Sir,
Sir,
fundamental
fundamental
rights are
rights are
negotiable.
basically human
Yes,
rights.
yes, who are you? Yes, Vidhi, yes.
So fundamental
Sir,
rights are basically human rights, which is guaranteed by Indian Constitution, and the directive principles are like direction which is given to the state.
Actually, I don't want the words of or the letters of Constitution. I'm just simply asking you that what is the difference between two?
Sir, in simple terms, we can say that we have a right to claim over fundamental right. If our fundamental right is infringed, we have a claim over it. We can go to court or we can go to any court or Supreme Court for it. But if our DPSP, that is directive principle, is infringed, we don't have a right to go to claim it. That
Who
is the
says?
simple and basic.
Who
Aksha
says?
Kumari.
No, no, no. Who says that you have no right to claim?
The DPSP is the direction given by the constitution to the state to act on a certain way. For example, if we talk about Article 44, that is Uniform Civil Code. So it states that there should be uniform civil code. Though we don't have a uniform civil code, but in Goa we have. So it
Okay,
depends on the
okay,
state
okay.
to work on it.
That's
It
a
is
big
not
issue. Okay,
enforceable.
okay. Okay, anyone? Anyone? Just the
So
last question.
fundamental rights are
Yes.
enforceable by courts, whereas in directive principle it is
Who
not
says? Who
enforceable by
says?
courts.
Who says fundamental rights are enforceable and directive principles are not enforceable? Who says?
Because sir, DPSP is the it guides the states in creating a just and equitable society, whereas fundamental rights protect the individual from the state.
Very simple question, and you have to answer simply. Very simple.
So
Rights
fundamental
is equal
rights are
to.
human rights.
Okay, okay, okay. Just I'm going to explain. Okay, the time is too short today. It's a very big topic. Uh, so fundamental rights. So rights is equal to protected interest. So fundamental rights are enforceable. Everyone is correct. Everyone is correct. What Article 37 says of Indian Constitution? Very simple. Everyone rightly says directive principles of the state policies are not enforceable. Clear? This is the words of Indian Constitution, Article 37. But if I ask you, what is the directive principles? What is the direction? These are the directions of our constitution makers. Constitution makers, they have directed to the state. They have directed to the state government and central government that please use the legislators, make laws on the basis of the directives. Now it cannot be enforceable, but in future it must be implemented. Why said? Because our constitution makers, they thought for social justice, they thought for economic justice, they thought for political justice. Now, you may ask me, sir, we can't understand. I'm giving you one simple example. One simple example. Have you heard the name of the case of Olga Tellis versus Bombay Municipal Corporation? It's an old case. It's an old case. Have you heard? Anyone? Have you heard the case of Maneka Gandhi versus Union of India? Have you heard? Anyone?
Yes, sir, I have studied it.
Yes, sir.
What was the fact of Maneka Gandhi's case? Maneka Gandhi, in the year 1977, she was ready for going to Kashmir, Jammu Kashmir. But when she was in airport, the passport officers, they came to her and the passport officers, they told her, Madam, your journey is prohibited. Madam says, why? Madam was furious. She was the in-laws of our Prime Minister Indira Gandhi and she was furious. Why? Then the passport officers told her, Madam, just you see, Section 10 of Indian Passport Act. We have the power to prohibit your journey if we think. Then Mrs. Gandhi was furious. She came ultimately before the Supreme Court of Law, before the premises of Supreme Court in the year 1977. And perhaps she did not know that it will create a history. What the Supreme Court says. Supreme Court says laws are made for human beings. Human beings are not made for laws. If any law, for example, Section 10 of Indian Passport Act, don't comply with the philosophy of Indian Constitution. If any law has violated the fundamental rights of anyone else, the law can be thrown to the dustbin. The law can be struck down by the court. Supreme Court struck down the provisions of Section 10 and interpreted on the basis of the principles of justice, theory of justice. What Supreme Court said? Supreme Court explained Article 21. What it said? Very simple word. Words are very simple. But interpretation is very, very bigger. What it said? Right to life and liberty. What life means? What does life means? It does not mean the mere animal existence. We are not beasts. We are not street dog. We are human beings. We have life. Just to see the meaning of life. Right to life. What is right to life? Right to life will include so many dimensional provisions of directive principles of the state policy. Right to livelihood, right to education. The journey of judicial activism started from Maneka Gandhi's case, and till date, the Supreme Court they're interpreting Part 3 and Part 4 of Indian Constitution on the basis of theory of justice and philosophy of our Indian Constitution. Is it clear to all of you or not? Is it clear to all of you or not?
Yes, sir.
Okay. Come to case of Olga. It is a very, very beautiful case for your understanding. What it says? Olga Telly's case. Have you heard it? Anyone else?
Yes, sir.
What is the fact of the case? Yes, Yasha?
Yes, sir. Actually, in this case, court held that right to livelihood as an integral part of right to life under Article 21.
Okay, anyone else? Olga Telly's versus Bombay Municipal Corporation. Anyone else?
It is right to life and personal liberty. Article 20.
Right to life and personal liberty. Okay, anyone else?
Sir, there was the fact of the case was that Maharashtrian women moved out of the slums because there was the fact that they were living on the land encroachment, something like that. So for the development, they were removed from it. So they moved to the Bombay High Court for it. And then the Bombay High Court held that it is a fundamental right of person livelihood, and the state has to compensate them because they have a local extendi on the particular state, and they have a right to life, life, a basic living standard that a person should have. and the state have the duty to provide it. That's what I have understood.
Yes, very good. Anyone else? It's a very, very important case.
Yes, sir. The main issue was that the eviction of pavement and small dwellers in Mumbai, those who were living there, and their right to livelihood was violated under Article 21 of the Indian Constitution.
Article 20 of the Indian Constitution. Very good. Okay, anyone else? There are 82 participants perhaps. So anyone? Ipshita, okay? Yes, Ipshita, yes.
Sir, in the case, it was argued that if the public spaces are also a part of residence, and it was also argued that the eviction would eventually lead to the violation of Article 21, which is right to life, and the Article 19, subsection 1, which is the right to reside in any space according to the people.
Okay. So anyone
So
else on
I would
all
like to
that
add
case?
something.
No, Asta, Ipshita. Okay, other participants, they are silent and video modes are switched off. Only my video mode, sir, is on, and it's obviously violation of my right. Yes? Anyone? It's a very, very important case. It's a case of pavement dwellers. It's a story of some pavement dwellers. They occupied what the pavement dwellers they do. They occupy pavements. It's illegal. It's an encroachment. Yes or no?
Yes.
Yes or no?
Yes, sir.
Have you seen the pavement dwellers? They have encroached.
Yes, sir. Yes, sir.
Yes, sir.
They have occupied illegally. So when the eviction notice came by the Bombay Municipal Corporation, so then they came before the court of law. They came before the court of law. And they pleaded before the court of law, the Milords, all we know, we are pavement dwellers, we have occupied pavements illegally, we have encroached pavements illegally. But what is the fact? The fact is that there is a directive by our Indian Constitution. There is a directive mentioned in Part 4 of Indian Constitution that the government, the state, must have to ensure our livelihood, right to food, right to shelter. So these are the constitutional mandates. If directive principles are not enforceable, if these are the mere declarations, then what is the use of it? What is the function of it? If directive principles are not enforced, then obviously it's a mere declaration, it's useless. In that particular case, Supreme Court made it very clear, yes, pavement dwellers, they have occupied, they have encroached. But simultaneously, our constitution makers, they have provided some fundamental policies fundamental directives to be implemented by the government in future. And Supreme Court interpreted right to life is equal to right to livelihood. Right to life includes right to livelihood. So directive principles have been enforced by the judiciary through the window of Article 21. Is it clear to all of you?
Yes, sir.
Yes, sir.
Only two participants says yes sir, but others,
Yes, sir.
there are
Yes, sir.
83 participants. I can't understand but they
So
are
you mean to say
Yes, sir.
right to livelihood is as an integral part of right to life under
yes,
Article 21?
yes.
Okay.
What is the meaning of mere declaration of directives? If they are not useful, okay, we are going to another beautiful case. Mahini Jain versus State of Kerala. Have you heard the case? Mahini Jain versus State of Kerala.
Yes, sir.
Who says yes, sir? Who says? Please. Okay, explain. I'm a learner, I'm a listener, learner also. I don't think myself as I'm a lecturer, but I'm a learner till that, yes.
So there,
Anyone?
the Supreme Court held that the right to education is a fundamental right. I I think so.
Education is a fundamental right. So Mohini Jain case, have you heard it? Search on Google.
So that
Now
I
Google
think
is
that is the
available.
Mohini. So that is the case of Mohini Jain, state of Karnataka versus state of Karnataka, in which the Supreme Court held that the right to education is a fundamental right under Article 21 of the Constitution.
Okay, what is Article 21A? What is Article 21A?
Right to education, no, sir. Right to education.
That
It's a
free and
fundamental right or
compulsory,
direct?
free and compulsory education for
Right
child.
to education, Article 21.
It's a
So
fundamental right,
free,
sir.
so free
Sir?
and compulsory education under by the state under 6 years. Every child have the
For the
right to
children
get it.
who are between 6 to 14 years of age, that is Article 21, which is inserted by 86th Amendment of the Constitution.
2005.
So, so you have heard the case of Mohini Jain, case of Unni Krishnan.
Yes, Unni Krishnan, I have heard, sir, that is
Krishnan
also related to
case.
education.
Yes. So, case of Mohini Jain. Anyone else? Anyone? Anyone? There are 81 participants. Just law is very simple if you can understand, but law is very tough if you don't understand the law. Okay.
Yes, sir.
Yes, Kushi. Yes.
Article 21A defines that education should be compulsory for the children aged 6 to 14, and it is inserted by 86th Amendment in 2002. This is what it was, if I'm right, sir.
Okay. Just I'm going to tell you a story of Mohini Jain. Mohini Jain, she was a poor girl, meritorious, poor girl. She cleared entrance examination for MBBS. She cleared medical entrance test. But when her father went for admission to the college, the college authority demanded the capitation fee of 60,000. Capitation fee of 60,000. But her father told, no, we are very poor. We can't afford it. My daughter, she has cleared the test. Then the college authority says, no, you must have to pay the capitation fee, otherwise she will not be admitted to the medical college. Then the father of Mohinijane came before the court, came before the premises of Supreme Court. It was pleaded before the Supreme Court that, my lord, there is a provision of right to education. There is a declaration of right to education for all in our Indian Constitution. But if these are not implemented, if these are not executed, then what will be the fate of the poor meritorious students? And what Supreme Court said, a beautiful word. Supreme Court interpreted very, very beautifully that yes, education is not a commodity for sale. You can search in Google, Mohinijane case, Unni Krishnan case, a very, very beautiful interpretation of Supreme Court. And then right to education was in Directive principles of the state policy. The Supreme Court said no. Education is not a commodity for sale. Mohinijane must be admitted before the medical college without capitation fee, because these are the directives of our Indian Constitution. Then if you say, my lord, this is not enforceable as per Article 37 of Indian Constitution, directive principles are not enforceable, then Article 21 is there. 21 says, right to life and liberty. That includes right to education, right to food, right to medical treatment, right to shelter, right to environment. All these are included under the purview of, under the broader ambit of Article 21. Just to see what now Supreme Court and High Court they are doing. They are implementing the constitutional provisions with the window of Article 21, Article 14, Article 19. Literally, we may say directive principles of the state policy are not enforceable as per the letters of Article 37. You are correct. You are constitutionally correct. But what the judiciary they are doing? They are beautifully executing, implementing the directives of our constitution makers. This was the dreams of our constitution makers. What was the dream? Social justice. Dream for social justice. Then the legislators, then the Indian Parliament inserted Article 21A. I have forgot the year. 21A.
2002.
Yes?
Sir, 2002 it was.
Yes.
86
21.
amendments, sir.
Yes, yes,
86
yes, very good.
amendments.
So inserted 21A. Right to education is a fundamental right. If we see the case of the old case of 1951, old case, where the conflict started between the versus fundamental rights and directive principles of the state policy. What was the versus? Fundamental rights and directive principles in the case of Champakam Dorai Rajan versus State of Madras after independence in the year 1951. Then Supreme Court said no, fundamental rights will take upper hand over directive principles. But if you see the chronology of cases, Golak case, and finally the Kesavananda Bharati case, Minerva Mills case, what is the interpretation of Supreme Court? What is the stand of judiciary? Fundamental rights and directive principles of the state policy both are, I am telling you very slowly, just to feel the word, both are supplementary and complementary to each other. They are not competitor that these are not enforceable, these are enforceable. No. No. These are supplementary and complementary to each other. Is it clear to all of
Yes,
you?
sir. Yes, sir.
I only hear yes, sir from 2, 3
Yes, sir. So
participants.
you
Yes,
We are
mean
sir.
to
90
you
Yes,
participants.
sir.
Yes, sir.
so you mean to say fundamental rights and DPSP should go hand in
I
hand?
don't say the court judiciary say. You search in Google, you see the textbook.
Okay, sir. Yeah. Thank you.
And another beautiful case we can refer the case of Kamal Nath versus MC Mehta. Have you heard the case? Anyone?
No, sir.
Yes. Anyone? Yes.
Sir, it was an environmental law case, no? Public
That
trust.
long case. Just tell something on the case. Now Google is available. Now study is so simple now and easier. AI
Sir,
is
if
now there. AI, we have AI, we have Google, we have everything. And for 2, 3 minutes we can read it. Anyone? Yes?
sir, sir, it was case of public trust doctrine. Basically, Kamal Nath have constructed a Sapan motel above a sea level, and they try to divert it. So people raised concern that you are trying to harm the environment. So the from that landmark case, the doctrine of a public trust came in.
Yes. Anyone else?
Sir, in short, he was harming the ecology of the river basin. That was, I'm not, and that court held that the government does not have a power over the environment, and it is not the owner of the forest. It can't
Okay.
give the protected land to the any contractor or sold out to anyone.
Okay. Okay. The other students who are not speaking, just say
It is
something. Just
basically
yes. Yes.
that it is especially the case of public trust doctrine where it's clear that government is the trustee of the of public property, and he has no right to use it for any public purpose or change the nature of the land, or change the or you can say that disbalance the environmental uh, disbalance the environment. Actually, the government has no right.
And the government is a trustee or what you say?
Yes, sir. Sir,
Trustee of what?
government is the trustee of public property, right? So
What
yes,
is public
no.
property?
Public property means, sir, like sea, right, like river, which is which have a large number of public has a right to use or exercise over it.
Okay, very good. Anyone? Okay. Maximum participant, you are silent. And I can't see you because this is online class. This is not offline class. I can't see you whether I can understand whether you understand my lecture or not. Okay.
So we are, but actually I am new into the law. I'll start my law college from September, so it is like I'm just understanding things right now. So it is like quite hard for me to get some things, but I'm trying.
Okay. That's not the problem. Now, okay, so I am going to tell you the story of Kamal Nath case. Mr. Kamal Nath was a very, very powerful minister at the time. His relatives, they started to construct a resort. And what is the name of the resort? Span Motel, perhaps. I have forgot. Span Motel. Okay. It was nearer to the river Bias. Now, the relatives of the minister, they are also powerful because minister is powerful. But you see, the constitution is more powerful than the politicians. For the construction of the hotel, for the construction of the resort, there is a diversion of the way of the river Bias. Just to imagine, we have diverted the way of the river Bias. Then one journalist, N.C. Mehta, he came before the Supreme Court. He pleaded before the Supreme Court that, my Lord, they have taken 16 acres land. And obviously, from the forest area also. What is the result of it? For the construction of the resort, it has damaged ecology. It has diverted the way of Bias River, and it will cause flood every year. And the poor people living there, they will be destroyed. Then Supreme Court said, yes. Yes. If the right of environment has been damaged by any activity, by anything, by any construction, then obviously it will be interpreted under the broader perspective of dash.
Article
Anyone else?
21. Article
Yes?
21.
Very good. Under the broader perspective of
Article 21.
only one, and the others
50,
just silent.
and also Article 51A of G.
Right to environment has been inserted, has been provided in the directive principles of the state policy. This is not fundamental right.
48A, sir.
48A. And 37, Article 37 clearly says that no, these are not enforceable. But what the court did, court followed the principles of Kesavananda Bharati case, of Minerva Mills case, That directive principles and fundamental rights, they are complementary and supplementary. They are not competitors. They are not master and servant, subordinate, superior. No. They are complementary and supplementary to each other. Supreme Court inserted, Supreme Court interpreted, Supreme Court explained. Yes, right to life is equal to. Right to life includes right to environment. Is it clear to all of you?
Yes, sir.
Is
Yes,
it
sir.
clear? I
Yes,
can't
sir.
understand whether you are
Yes, sir.
Yes,
Yes,
sir.
sir.
It's very clear. It's very clear.
clear. So from the beginning, just I am going to the gist. What is the standpoint of judiciary? Fundamental rights and directive principles are not competitors. They are dash. They are
Complementary and supplementary to each other.
they are
Complementary and
They
complementary.
are complementary and
they are
supplementary to each other.
they are
Not enforceable.
supplementary
And
and
And complementary.
complementary.
to each other. Clear? Okay, my
Yes,
time
sir.
is going
Yes, sir.
over. It is
Yes, yes, sir.
8:30. And any question? This is clear to all of you or not?
Yes,
My
sir.
lecture is
Clear, sir.
clear.
Yes, sir.
Yes, sir. Clear,
Yes,
sir.
sir.
It's
Yes,
clear.
sir.
It's very clear. Very clear. Very clear.
So may I leave now?
Yes, sir.
No, sir.
No,
I
sir.
have some doubts.
Okay. Yes.
Sir, I wanted to ask that how should I start my legal journey? Actually, I haven't started any legal topics in something. So what should I learn first?
How should I can't understand. How should you please?
Actually, I've just started my legal journey as I told you that I'll join my college in September. So I'm not sure how to start it. Where should I start my study from?
No, just to see, just to take the textbook. Okay, for instance, Constitution, the basic Indian Contract Act, Indian Penal Code, Law of Evidence. Just to take the Bare Act. What
Yes,
does it
sir.
mean? Bare Act means the legislations where the provisions are there, sections are there. Okay,
Yes,
and
sir.
take just one book as you like. Okay,
Yes, sir.
then just you read the section, read the preamble of the act, because preamble is the key. For example, Indian Contract Act, for example, the Consumer Protection Act. Every act has a preamble, objective. Just to read it, like Constitution.
Yes, sir.
Constitution has a preamble. Just to read it. Preamble is the key for opening the mind of legislators, opening the mind of constitution makers.
Constitutional maker.
Yes?
No, sir. I'm just telling that preamble is the key of making constitutional makers. It's from this preamble we can read the mind of constitutional maker.
Yes. And just if you read the any legislation, okay, just to see the preamble portion, short title, preamble. Okay.
Yes, sir.
Okay. So may I leave? I'm asking permission to you.
Yes, sir.
Sir,
Thank you very much,
sir,
sir.
Thank you very
Okay.
much, sir.
Thank you, sir.
Thank you, sir.
Okay. Thanks to all of you
Very
for
informative
thank you,
session
sir.
for us,
Thank
sir.
you.
Thank you so
for
much.
patiently listening my
Thank
lecture.
you,
Okay,
sir.
okay. Okay,
Thank you,
okay.
sir.